Okay, how you doing today? This is Sherman Crockett from ShermanCrockett.com, and as you know, I have that's my political blogging website where I blog about politics, sometimes religion. I want to talk about this recent Supreme Court decision last Thursday that upheld President Obama's Affordable Care Act, commonly known as Obamacare. And I want to draw a distinct correlation or relationship between that decision and the Brown versus Board of Education decision of May 17th, 1954. Because just as the Affordable Care Act was denounced by those who disagreed with it, so was the Brown decision. As a matter of fact, some of the things I'm going to tell you about the Brown decision, you're going to think I'm talking about the Affordable Care Act or Obamacare. I want to start off by saying that Obamacare is not perfect. Like most citizens, I have not read the whole bill. The bill is about 2,700 pages long. I have not read it, but what I do know about it, I know that there are many people who need it, people with pre-existing conditions, which usually ends up being mostly women. People who need to stay on their parents' health insurance until they're age 26. That would be students in college, students who are just getting out of college, and students who are just entering into the job market, whether from college or from high school, etc. So I want to talk to you about this article that I posted on my website yesterday, ShermanCrockett.com. So what I'll do is when I finish this video, I'll post this video also on my website, as well as I'll tweet it and put it up on my Facebook page. But anyway, here's the article that I wrote yesterday and posted on ShermanCrockett.com. And I hope that you'll, for those who like to read, read it. For those who don't want to read it, listen to this video. Barely had the ink dried on the U.S. Supreme Court's 5-4 decision upholding President Obama's signature health care legislation before certain states, goaded by their Republican-led legislative majorities as well as governorships, dug their heels into the ground and defiantly declared that they would refuse to begin its implementation. Lest we believe that this response to the court's decision is a novel one, let's take a minute to both read a few remarks made in the name of interposition and nullification and take a brief trip down memory lane. Here are the words of Georgia Governor Nathan Deal, who's a Republican. Quote, "While we realize this is a huge setback for fiscal sanity and personal liberty, we are not giving up." End quote. Congress must now work steadfastly to repeal this law. Actually, that was the end of the quote. Louisiana Governor Bobby Jindal, also a Republican and thought by some to be a vice presidential possibility. Quote, "Here in Louisiana, look, we refused to set up the health care exchange," or the exchange, I put the word health care in there. "We're not going to start implementing Obamacare." You hear that? We're not going to start implementing Obamacare. Doesn't that sound like what the states said after the Brown decision in 1954? Listen to South Carolina Senator Jim DeMint, a Republican who's also a darling of the Tea Party. I urge every governor to stop implementing the health care exchanges that would help implement the harmful effects of this misguided law." End quote. And this profound polemic from former Alaska Governor Sarah Palin, also a Republican. Obama lies, freedom dies. Forgive my false surprise, but I thought that these were statesmen who most believed in the rule of law and who called themselves true patriots and glorious defenders of our beloved Constitution. Now let's take a brief trip down memory lane and examine some of the responses to the Supreme Court's Brown versus Board of Education decision, which was May 17th, 1954. In 1958, instead of complying with the Brown decision, Virginia underwent a campaign of, quote, "massive resistance," end of quote, which resulted in some of its schools being shut down for 5 years. Rather than comply with the Brown decision, rather than comply with what the Supreme Court of the land said, Virginia, the so-called cradle of democracy, the cradle of the Republic, which of course was also the cradle of the Confederacy. Let's not forget that. Virginia shut down some of its schools for 5 years. If you think that's crazy, listen to what Alabama did after the Brown decision. In Alabama, state officials had the myopic gall to tell its needlessly frightened citizenry that the Brown decision, quote, did not involve Alabama, end quote. Let me say that again, because I think some of you are rubbing your eyes or your ears. In Alabama, state officials had the myopic gall to tell its needlessly frightened citizenry that the Brown decision did not involve Alabama. Imagine that. As the highest court in the land, the Supreme Court had issued a unanimous decree stating that public school segregation was not only legally but morally incompatible with America's ideals. And Alabama officials, apparently forgetting that the Civil War was over and that the nation had once again been reunited, told its citizens that they were exempted from the court's landmark decision. Of course, I could mention how other states reacted to the Brown decision, but my point is clear. Those who claim to love our Constitution only love it when courts rule in their favor. Is Obamacare perfect? Far from it. And like most Americans, my knowledge of it is limited because I haven't read the whole 2,700-page bill. But from what I do know, I have to support it if only because, one, it prohibits insurance companies from denying full coverage to persons, usually women, like my wife, who is diabetic, with pre-existing conditions. Two, it prohibits insurance companies from charging women more than men. That's an equal protection issue right there. That's a 14th Amendment issue right there. And three, it allows children, many whom are either just entering their job career, one of our daughters, or are just graduating from college, or are still in college, from being dropped from their parents' insurance coverage until they reach age 26. And four, no matter what they tell you, Republicans don't have a better plan, but are water carriers for the nation's insurance companies. In closing, I realize that Chief Justice John Roberts, a George W. Bush appointee who wrote the majority opinion, didn't suddenly become a liberal ideologue, but rather he placed future constraints on Congress's use of the Constitution's Commerce Clause. Although I think that Obamacare could have been justified under the General Welfare Clause, or even under the Equal Protection component of the 14th Amendment, equal protection for all citizens. All citizens need health care. Not all citizens can afford health care, especially those with pre-existing conditions. So in my opinion, and I'm not a lawyer, but I do love the law, I do love the Constitution, I do love this country. Whether the rulings are in my favor or not, I still love the Constitution and I love this country. But I think Obamacare could have been upheld under the Equal Protection Clause of the 14th Amendment. And if not, under the General Welfare Clause, which is Congress's duty to promote the general welfare of the nation. But anyway, Chief Justice Roberts, a George W. Bush appointee who wrote the majority opinion, didn't suddenly become a liberal ideologue, but rather he placed future constraints on Congress's use of the Constitution's Commerce Clause. Although I think that Obamacare could have been justified under the General Welfare Clause, like I just said, he placed the issue in the hands of the voters who will either re-elect Barack Obama in November or will remove him from office. Some, including myself, think this was a stroke of judicial genius. And some even think that Roberts was, in his own unique way, apologizing to the president for flubbing his inaugural swearing in. That's my opinion. What's yours? Have a good day, and God bless you. I hope you listen to the video or read the article online, and feel free to comment, please. I'll post it on Facebook, YouTube, and Twitter within the next few hours. All right, God bless.